Welcome to News Now Alberta. This is Special Ed. Today we're looking at a compilation of a judge in Texas, Judge Fletcher. He's a pretty good judge. What he does, he throws out cases or he helps people that have been wrongfully arrested by the police. A lot of his court cases that he throws out is for black people that are arrested for being black and basically no other reasons. So check out this compilation.
Let's roll, nerds.
Good morning, Your Honor.
Hey,
How's it going?
it's been a while. How are you? What's
Doing all
new?
Yes. Let's guess.
I'm right. Thanks. Good morning, Mr. McGaskey. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Mireles picked up a new case.
Yeah, and he came in, checked in and left saying he had other places to go.
What?
I warned him that if he left, that more than likely a warrant will be issued for his arrest.
Next time,
I can't, if he's on bond, I take him. That's part of the problem.
all right.
But I agree.
Mr. McGaskey, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Just please don't say it.
Okay. October 26th, officer was dispatched to a major crash in Harris County, Texas. Upon arrival, the officer observed the defendant sitting in the driver's seat of his motor vehicle with his keys in his lap and with an odor of an alcoholic beverage. The defendant stated he drank prior to driving. Standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath, but the defendant was unable to do the test. A blood warrant was then signed and executed.
It was really quick. So where was he?
So it was a major crash in Harris County, Texas, specifically on 2201 Southwest Freeway.
Okay, and then what?
The officer arrived and he was in his driver's seat, and the officer observed his keys in his lap, and then he observed an odor of alcoholic beverage.
Just an odor. Anything else?
And then the defendant made a statement that he drank prior to driving.
Yeah.
And that's it.
Leads you to believe that he's drunk. We have an accident, I get it, but there's just an odor of alcohol. There's nothing, no slurred speech, no bloodshot eyes, just an odor.
Yes, sir. All that was written was the odor was observed, and then the statement made about him drinking.
McGaskey, I have an accident. All I have is an odor of alcohol. What can you, other than the accident, what can you lead me to believe that he's drunk or intoxicated?
The defendant stated he drank prior to driving.
We don't know how many, we don't know how much, we don't know when it was happened.
Well, Judge, I don't think that's necessary to provide probable cause for the case. He's admitting to drinking, he's got odor of alcohol in the breath, and the accident itself is evidence of intoxication, Judge. All of that, in our opinion, is enough for probable cause.
I don't think so. I mean, usually there's a lot more than just that. An odor, we don't have anything else. I don't know when, I don't know how many, I don't know how strong it is, just an odor.
Not every case has extrapolation or admissions of how many, Judge.
I understand
It's
this.
just
I understand, Michael, but I need just a little bit more than just an odor and an accident.
An admission to drinking, Judge?
Okay, we don't know when. The officer can't do any more questions than that. Okay, when did you do it? How many did you have? Did you have anything to eat?
Understood.
Yeah, all right, no, I'm gonna find no probable cause, Mr. McGaskey. It's very possible if they take it to a grand jury and indict it, but so I would be on the lookout, number one. Number two, you know how many accidents and death we have every day due to alcohol and getting into a car? I'm gonna find no probable cause. Just take a seat for a moment.
Thank you, Judge.
Thank you, Mr. Jeff.
So the officer here half-assed his report thinking that, it's going to go through and no one's going to really care. But this judge doesn't leave that happen. You have to have specific information. The guy could have been drunk. He could have hurt someone. Because he was drunk, but we'll never know because no questions were asked. I mean, this guy should be free to walk away because the police officer didn't do his job.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the gyms, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the one leg stand. He also noticed that I think she took off her boots for the one leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, just an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her, I mean, which is per, you know.
But I get the
SFSTs,
SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough.
see what-
An odor of alcohol in and of itself is insufficient.
But
Yeah.
it seems that this stop occurred at 2 a.m. and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button. You have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
All right, please take a seat.
So this was another DWI. I have a few DWIs that he threw out because the cops didn't do their job. She drank 2 beers 2 hours before she drove. So if you look at 1 hour to dissipate 1 drink of alcohol, then her 2 drinks would have been dissipated by then. Was she drunk? Was she not? We'll never really know because nothing was really proven at the stop, and this judge didn't let it pass. So I have a lot of admiration for this judge. Let's continue.
You are Keon Shaw.
Yes.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27th, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You know,
I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
DMs.
let's do this. I'm going to have them because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're going to have to do a little deeper dive. If you just mind taking a seat for me momentarily, okay? Okay. Don't leave, Mr. Shaw. Okay, who's next?
So this was clearly driving while black. The excuse is always like, "Oh, you were speeding," and then give me your license. I want to see who you are and run you for warrants. If he would have had proof of him speeding, it would have been written in the report or on the actual ticket if the guy got a ticket. It looks like this was clearly driving while black, and the judge saw right through it. You don't see the place where they came back and said in the video where the officer didn't write down what speed that he was driving. So the judge kicked that out with no probable cause. This is mostly a probable cause trial that this judge takes care of, and he kicks a lot of them out because there is no proof of anything. People were just arrested to be arrested.
How old are you, ma'am?
17.
Are you here with anyone today?
Yes, sir.
Go get her, please. Yeah. Good morning, Mom.
Good morning.
Thank you so much for coming.
Yes.
So Ms. Smith is charged with evading arrest or detention. She's facing up to a year in jail and or a $4,000 fine.
The vehicle was observed to be occupied by 3 subjects, one of whom was the defendant, who was observed to be in the front passenger seat.
Is this deja vu?
And the officer followed the motor vehicle and confirmed the occupied vehicle to be stolen. The officer activated his emergency equipment in an effort to initiate a traffic stop, but the officer observed it to take off and refused to stop. The officer observed the vehicle reach speeds of 66 miles per hour, disregard all signals to stop, and run a red light. When the vehicle eventually stopped, the defendants got out of the vehicle and evaded on foot for approximately 1,000 feet.
It's like I'm hearing double. What are you doing with yourself these days, ma'am?
Going to school.
Where?
She's doing good too. Cyclops High School.
She's here with me now. She's got a
She's getting ready to graduate. She's doing good. She makes good grades. She got some plans after school. She loves to work. She was just, I don't think she was really knowledgeable.
Let's not talk about the case.
Okay.
If I test you for drugs and alcohol right now, what are you going to test positive for? Exactly. I'm sending you for a test. It stops today. And if I find that you start acting up, if you don't stay in school, if you start hanging around with these people again, I've got one place for you. Do you understand this, Smith?
Yes.
The goal is to make you leave here better than you came in. And I'm going to do everything in my power. And if I see that you start acting a fool in the free world, I will take the free world away. And I don't care if you're kicking and screaming and praying to Jesus, Allah. I don't care. You start acting a fool, there's only one thing that's going to happen. I'm not asking much. The only thing I'm asking you to do is stay clean, graduate, and make something of yourself. Life is hard enough for you as it is. Who you are. You now are here with us as a first. Don't make it a career. It's not a good one. Life is about money. And you, as a young Black woman, should never, ever have to rely on anyone else for money, because no one is going to give anything to you. If you want something in life, you got to go get it. And you need this, and you need this. And it starts now at 17. Do you understand?
Yes.
Okay. Same thing with you. I will give you guys a lawyer today. I'm sending it for a drug and alcohol test, and I'm putting a curfew. Nothing good happens in the middle of the night, and you're not allowed to. I want you to stay in school, graduate, and you're not allowed to hang out with the people in this case, the other co-defendants. Do you understand?
Yes, sir.
If you ever have any issues, just let me know, and we'll try to help you as much, and we'll try to take it, no money as well. And I'll give you my card. If you ever need anything, just let us know, and we'll help you take care of everything as we can.
Appreciate you.
For sure. Do you mind giving me a drink, please? Okay, so for now, I'm sending you for a test. If you were to come back, if you fail the test, if you don't come back, your bond goes bye-bye. Do you understand?
Yes, sir.
Okay. All right, Vic, please.
So this one is a little different. He did find probable cause, but he showed a lot of compassion, trying to help her, be a better person, stay in school. And curfew was a good idea. Just like he said, there's nothing good that happens in the middle of the night. So even though there was probable cause here, because she was a passenger, which is not bad, but she did run from the cops, which you're not allowed to do. So probable cause was probably well deserved here.
And you have 2 children. You realize by pleading guilty, who do you think's going to get wind of this? And do you think that they're going to think this type of person is a safe place for 2 kids? CPS.
Talk about that.
You think I'm bad? Wait till CPS gets involved.
I agree. CPS is worse than Judge Fleischer.
Who are you going to test positive for?
That's the only thing I'm scared of. I don't want to.
You should be scared because it's depending on what are you going to test positive for? Guys, we have a problem now. We have a big problem. I will not accept any plea of guilty from you now. Not at you're 19 with 2 kids and now you're taking Percocet? Nope. Take a seat for me at the jury box, ma'am, please. We'll have to figure something out now.
So here he didn't want to get a guilty plea off of her. It would have probably ruined a good part of her life. He's going to try to work with her and see if he can cut a deal just to help her out here. Because, like you said, you have 2 kids and Percocet in your system doesn't look good.
Officers were dispatched to a possession of marijuana investigation at 100 Hollows Tree Lane in Harris County, Texas. Officer was informed defendant crossed unauthorized crossing point from convenience store to apartment complex. Officer observed strong odor of marijuana.
Wait. He did what?
It says he crossed an unauthorized crossing point. So I guess he crossed the street.
Is he jaywalking?
Yeah. Yes, Your Honor. And then
Walking while black.
and it says the officer observed a strong odor of marijuana and he was informed that the defendant had begun to walk backwards upon being asked about marijuana by another officer. A PC search was conducted and the officer observed a large sack of marijuana.
I don't think so. Walking while black. I don't think so. I'm going to find no probable cause.
Yes, Your Honor.
Mr. Blake, be careful, man. You know, the world is against you. Don't let him be. Do something with your life. You know what I mean? The more you just, come on, man.
No, this is clearly walking while black. They'll always use a jaywalking if you're crossing somewhere that you're not supposed to, or, they think you're not supposed to. And then they find that it's probable cause to search you, which clearly the judge laughed at because it's not. It's truly not probable cause to search you because you walked across the street.
Morning, Mr. McLean. Sir, you're charged with interference to the duties of a public servant. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Your Honor. An officer initiated a traffic stop in Harris County, Texas, after observing the defendant exceed a speed limit of 45 miles per hour and make unsafe lane changes. The defendant did not have his driver's license, but told the officer his name and date of birth. While the officer was running the defendant's name, he observed the defendant exit his vehicle, and the officer told the defendant to get back inside the vehicle. And the defendant responded, "Do I have to?" The officer exited the vehicle and attempted to detain the defendant. The defendant tensed up and locked his arms.
Everything is conclusory. What has he done wrong?
You're wrong.
What?
was the initial lane changes, unsafe lane changes, and the exceeding the speed limit that prompted the stop. And then at that point, he was just attempting to get
Stop.
information.
How exceeding speed limit? How fast was he going? I mean,
I spoke to the officer this morning, who told me that he was pacing the defendant at 54 miles per hour.
okay, in a what?
I'm sorry?
In a what? I mean, if it's on 610, he's fine, right? And then he's interference duties. What is he interfering with? What did he do wrong?
I think it was after the stop was initiated, the officer was running the plates. The defendant stepped out of his vehicle. The officer told him to get back in the vehicle. The defendant said, "Do I have to?" The officer told me that.
And that's the basis of arrest?
See how it
Can I
was,
speak,
Your Honor.
please?
Don't. Are you losing?
No, sir.
Okay.
And Your Honor, furthermore, as he was attempting to detain him, he locked his arms and tensed up. So as he was attempting to detain him, following that incident of him telling him to get back in the vehicle. And it was
That's the basis for arrest.
it was just a
Walking
temporary
while black?
detention. He was just attempting to detain him while he was trying to
What's he
investigate.
doing wrong?
He had
What's he doing wrong?
65.
No, I don't think so. Mm-mm. I'm to find no probable cause. No, it's just, he gets out of the car and then it just the virtue of fact, him getting out in the car is interfering with the duties. Really? No, just when you get into, just be careful out there, man.
Yes, sir.
Life is hard as it is.
Yes, sir.
When you get into, gotta be careful, man.
Yes, sir.
People always out to get you. Be nice. It's not hard.
I was
Things
being
will go well for you,
Too.
Look, I got it. I'm with you, okay? Just hang tight with me for a second, okay? All right.
So this had to be the best one. Yeah, he came out of his car and all he asked is, do I have to get back in my car? He doesn't know the rules. He doesn't know the law. He asked. And that was enough to detain him, really. And they always use he tensed up. If somebody's grabbing my arms and shoving them behind my back, I tense up too. Like it's a normal, natural reflex. But the cops always use it as, tensing up is resisting arrest. This was laughable. I mean, good thing there was no probable cause here. Because even in the courts, getting the wrong judge in the court, he could have been found guilty of these charges, which is absolutely ridiculous. Now, if you like this video, please like, share, and subscribe. Leave a comment. Let me know what you think of this judge. I think he's pretty awesome. Check out my Patreon, where for $1 a month, you can get my videos a week in advance with other perks coming. Thank you.